You call your bank about a frozen transfer, and the person on the phone tells you almost nothing. Not because they're hiding something shady, because federal law makes it a crime for them to tell you more. That's the freeze clock. It starts the moment your account locks, and almost nobody explains how it actually runs. Here's the law behind that silence, because it changes how you should react to it. If a bank files what's called a suspicious activity report, a formal filing that flags a transaction for federal investigators, the law makes it illegal for that bank to tell you the report exists. It's called tipping off, and it's a real federal offense on its own, separate from your actual case. In plain terms, when a bank rep says your account is under review, we can't share more, that's frequently not evasiveness. That's frequently the only legal sentence they're allowed to say to you. Here's what that actually means for you if you're staring at a frozen account right now. Stop waiting for an explanation. Start building your own file because the bank isn't going to hand you the answer. And legally, in some cases, it can't. Now, here's the part that actually determines how this resolves: the mechanics of what happens after the freeze hits. Simple administrative holds, routine KYC updates, a basic verification gap, typically clear in 3 to 7 days once you provide documentation. Compliance reviews tied to a specific flag transaction usually run weeks, not days, because a human compliance officer has to manually review your file. Complex cases involving potential anti-money laundering concerns can take months. There's no guaranteed timeline. The bank's queue moves on volume, not urgency. In plain terms, the length of your freeze tells you almost nothing about your guilt. It mostly tells you which queue you landed in. Most people hear compliance review and assume the worst. Don't make that mistake. Strip away the institutional language, and here's what it actually means. A person, not an algorithm, is now reading your file, and that person needs specific documents to close it. Here's exactly what that documentation packet should include: your exchange statements showing the trade or sale, your trade history, time-stamped and complete, a tax document if the crypto sale already appears on a return, and a clear written timeline of events, plain language, no jargon, explaining where the funds came from. Think of this as a chain of custody explanation, a simple dated account of how the money moved, from the original crypto purchase through the sale to the deposit that triggered the review. Put simply, don't wait for the bank to ask for this. Prepare the packet before you make your first call and hand it over unprompted. Here's the step almost everyone gets wrong under pressure. Customer service representatives cannot unfreeze your account. They don't have that authority. Ask directly for the compliance department and, if possible, the name of the specific officer handling your case. Be polite. Be persistent. This is a relationship you're managing, not a fight you're winning. Here's a mistake that turns a temporary review into a permanent problem. Do not close the account while it's frozen. Closing it can read as obstructive, and it removes your ability to keep communicating with the same compliance team that already has your file. And do not open a second account to root around the freeze. Banks and exchanges share identity verification data internally, and a second account gets linked to the frozen one almost immediately, converting a temporary review into a permanent closure. In plain terms, patience inside the existing relationship beats any workaround you can think of. One more practical move while you wait: test every exit available to you. Freezes are frequently partial, not total. A fiat withdrawal might be blocked while a different asset or a smaller transaction still processes normally. Don't assume everything is locked just because one path is. Now, here's what to do if 30 days pass and you're still stuck in silence. At that point, escalate in writing. Send a formal complaint through the institution's official complaints channel, stating the amount held, the dates involved, and exactly what documentation you've already submitted. This creates the paper trail every later step depends on. In the US, you can also file a complaint with the CFPB, the Consumer Financial Protection Bureau, the federal agency that handles disputes between consumers and financial institutions. A CFPB complaint legally forces the institution to respond within 15 days. That's a real deadline backed by a federal agency in a process that otherwise has none. Here's when this moves from a compliance problem into a legal one. If the freeze has run well past 30 days with no resolution, If the amount held is grossly disproportionate to whatever's actually being reviewed, or if the institution appears to be violating its own stated procedures. That's the point to consult an attorney who specifically handles financial or cryptocurrency disputes. A lawyer at this stage can do a few concrete things for you. They can communicate directly with the institution's compliance team using language that carries more legal weight than a customer complaint. They can identify whether the institution has actually violated its own account agreement or applicable banking regulations. And in ownership disputes, shared accounts, contested transfers, they can pursue what's called a proprietary remedy, a legal claim asserting your ownership right to the specific funds being held, sometimes resulting in a court ordered release. In the rare case where the institution itself becomes insolvent while holding your funds, that shifts into bankruptcy court, where you'd file as a creditor to recover what you're owed. Put simply, litigation is the last resort, not the first move, but it exists, it works, and knowing it's there changes how you negotiate every step before it. Here's your structural takeaway: no hedging. Prevention still beats resolution every time. Everything we covered in the last video, keeping accounts active, calling ahead, documentation ready in advance, remains your best defense. But if a freeze happens anyway, the sequence is: build your documentation packet immediately, reach compliance directly, keep the account open, test every exit, escalate formally at 30 days, and bring in a lawyer only if the institution stops responding to legitimate process. That's the freeze clock. It's not designed to punish you. It's designed to move at the bank's pace, not yours. And now you know exactly how to make it move faster.